Welcome to Gracefully Graying. I am co-founder Lori Bloom. Explore a platform of tips, trends, news, and informative discussions for you and your loved ones. Whether you're 50 and over or way over, find us on gracefullygraying.com, YouTube, and social media. Enjoy this live stream discussion.
Welcome to Gracefully Graying. I'm your host, attorney and co-founder of Gracefully Graying, Henry Gornbein. Today on Gracefully Graying, we will be discussing a recent case where a resident of an assisted living facility was able to retrieve a substantial sum of money out of bankruptcy with my guest, Michael Lieberman, an attorney with Lipson Neilson. Michael, welcome to Gracefully Graying.
Thank you, Henry.
First of all, why don't you tell our viewers a little bit about who you are and your background?
Okay, I am a licensed attorney in the state of Michigan, have been for over 35 years. I primarily practice in the area of bankruptcy and creditors' rights. For the last 16 months approximately, I've been with Lipson Neilson as a partner in the bankruptcy department. And prior to that, I had my own firm in Farmington Hills for about 12 years, where we practiced almost exclusively bankruptcy and creditors' rights and debtor-creditor relations.
Now, Michael, you had a client who had a substantial deposit with an assisted living facility. First of all, what is the reason for a deposit over and above whatever the monthly rent or expenses are?
Well, I think what happens, different assisted living facilities have different business models, and the particular one that we were dealing with had a model where the residents, as part of their admission, would pay a substantial upfront fee, which was supposed to be a refundable fee. And in this particular case, I actually had two different clients. One was a trust who, the trust individual who had the trust, she was a resident of the facility and she subsequently died, and I was representing the beneficiaries of the trust. The other case, which is the case that we're primarily talking about here today, was an individual who currently still resides in the facility, and she now is a tenant in the facility because the business model changed. And by way of explanation, when the entity filed Chapter 11, usually what happens is in a Chapter 11 is the entity either reorganizes its affairs and files what's called a plan of reorganization, but in other cases there might be a liquidation, and in this particular case there was a sale where the assets, all of the assets of the entity were sold. The purchaser was an experienced assisted living facility. They had a number of facilities throughout the country, and they changed the business model. So to get back to your original question, in the debtor company, the company that filed bankruptcy, had a program where these individuals would pay an upfront fee that was supposed to be held in escrow while they were residents of the facility. And then if the individual ended up ceasing the relationship either by moving out or by death, then that deposit was refundable, and this would go back to either the resident or the resident's trust in one of my cases, and in the other case, the resident was able to recoup her admission fee because of the change in the business model.
Why did the facility file for Chapter 11 protection in this case?
Well, I don't know all the reasons why the entity may have filed for Chapter 11, but one of the reasons was that they had problems with issuing refunds to residents who were entitled to receive a refund. The escrow fund, or the fund that was supposed to be held and segregated for the benefit of the residents, was short, substantially short. And so my client, the one that died in the trust that I'm representing, and they had a claim for $204,000. That was the amount of the admission fee. And in that case, the estate or the trust is going to receive approximately the estimate is between 23 and 40%. They've received some of their money already. There remains additional funds that will be paid, but the refund that client was receiving is severely compromised. In the other case, the case that you and I had spoken about briefly before, there was a situation where the state of Michigan learned that there were problems with the escrow account for this facility. And so the Department of Licensing and Regulation got involved, and they then required new admissions, new residents who were admitted into the facility to have their resident admission fees escrowed with a third party. And so it created a different pool of funds for newly admitted residents who then were entitled to receive refunds out of the segregated third party escrow. And that's the client that was the one that, again, that is the subject of this conversation.
Michael, in the case that we're discussing, how much was involved?
$107,000.
And I'm thinking out loud, and it almost reminds me of the fact that as attorneys, we have to have clients' funds in what is known as an IOTA account so that they're not commingled with other funds. So it seems, is this similar? The whole idea that the funds of those residents should be kept segregated, so if they need to leave or that they're entitled to it. And it sounds to me like the facility owners were dipping into these funds. Correct me if I'm wrong, but that's the impression I'm getting.
That is, again, that was, I believe, what happened because the entity was having financial trouble. That's one of the reasons why they sought the bankruptcy relief, and one of the reasons why ultimately the facility was sold.
Michael, what was the involvement with the state of Michigan?
Well, my involvement was limited to trying to get the refund back for my client. I had involvement with representatives of the Department of Licensing and Regulation, or Regulatory Affairs, had communications with counsel for the facility that filed, the debtors counsel. I also had communications with the attorney that was representing a group of creditors in order to try to get my client paid. And so there was a lot of red tape that I had to go through in order to secure the return of the funds, but we were able to do so after ultimately reaching the right people, including as I said, the individual representative from LARA, the Licensing and Regulation.
Michael, from your perspective, what was the main issue with regard to your client with regard to this bankruptcy?
The client who received the $107,000 refund, is that?
And it seems like it should have been fairly simple that this money is in escrow, it should have been there, but it wasn't so simple, was it?
Well, no. What happened is with the first client whose claim was compromised, the process in bankruptcy is when an entity files bankruptcy, the creditors have the ability to file what's called a proof of claim in the bankruptcy, which documents the claim and the amount of the claim, and the supporting information is provided for it. So that particular claim was reviewed by the debtors counsel, and ultimately we reached an agreement as to the amount of the claim because our records and their records were fairly close in terms of how much the claim was. With the other client, the client who received the full refund, $107,000, the case had already been filed, and the process had already started in terms of those claimants, which were called the LARA claimants, getting paid back their money. And so I came in somewhat as the case had already advanced. The case was further along in the process with that client, and so the parties understood and recognized the amount of that client's claim. It was documented in the bankruptcy schedules that were filed by the debtor entity. So there was no dispute over the amount of that particular claim. And then once we were able to verify who the client was and who was entitled to be paid, that's when the client was able to receive payment.
Michael, how long did the case take?
The case was filed in October of 2020, and one of my clients got paid in July, and the other client received the initial distribution in August. So that case pended for over a year and a half.
And your client with $107,000 got the money back, correct?
Correct. In fact, what happened is that apparently a distribution was made to that client. At least the records, according to the escrow agent, were that they had already made a distribution to the client, but for either my client never received it, or if she received it, she never deposited and negotiated the check. So an added wrinkle that we had is we were able to agree that the payment that was initially issued would be voided out, and then the escrow agent reissued a new payment to the client, and they did receive that payment, and it's been negotiated, so that client's been fully satisfied.
Michael, was the residence sold?
Yeah, in the bankruptcy case, the residence was sold to an entity that owns a number of assisted living facilities throughout the country. There was competitive bidding for the sale. There were a number of parties that were interested, and ultimately the successful bidder was determined, and the sale was completed, and new ownership took over and is managing the facility as far as I know.
What happened after the sale of the assisted living facility? Were changes made, or what's going on?
Well, yeah, and again, my involvement in the case was somewhat narrow in terms of just representing these two claimants, but my understanding is they changed the format of how they dealt with the residents. So existing residents were able to convert their residential agreements to essentially a lease arrangement. And so my client, who is still living there, the client that's still living and is still living there, she has a monthly residential lease where she pays her monthly rent, or the family pays her monthly rent on her behalf, and she will live there presumably, until either she decides she doesn't want to live there anymore, or until she ultimately passes away.
So she's still living there.
Yes.
Like a tenant who'd be renting an apartment. Would be a similarity with regard to this assisted living facility for her now?
Yes. And again, depending on the level of care that she needs and things like that, I'm sure that impacts what her monthly rent is.
What is the difference in business models between the original owners and the new owners, if you could explain that for our viewers?
Well, again, the initial, the debtor entity, the initial owner of the facility, I don't know if they offered multiple options to its residents, but the option that my client, or the arrangement that my client had, was the upfront deposit, live there for essentially as long as the resident wants to live there or until their death, and then the upfront payment would be refunded less certain charges that would be assessed against the resident. For example, rehabbing the unit if it needs repairs or cleanup or things like that. And then there's some other miscellaneous charges, but the bulk of the money was supposed to be refunded back to the resident. And with the second, with the purchaser, after the purchaser purchased the facility, as I said, they discontinued that type of arrangement. So existing residents who had their deposits, had their deposits made if they were part of the LARA group of claims, which was a small group of the claims, because the state of Michigan got involved a short period of time before the bankruptcy was filed. But that group of claimants was able to receive back their entire refunds of their admission fee. And then, as I said, their arrangement through the plan of reorganization that was approved by the court provided that those residents would convert to a more conventional type of lease arrangement.
So basically, are there different models for people who are thinking of either going into an assisted living facility or senior residents themselves or their parents? I mean, what advice would you give if it were your parents contemplating going into an assisted living facility as to how to handle some of these monetary issues?
Well, I think I'm by no means an expert of what the different assisted living facilities offer, but from my personal experience having a family member who is in one of those facilities, her arrangement was somewhat different. She had a security deposit that she paid up front, and she's paying rent on a monthly basis now. She has a long-term care policy, so she's getting assistance through that policy, at least temporarily. Then, as I mentioned before, there's the situation where these facilities require the upfront deposit. I'm aware of some facilities where you actually have an ownership or an equity interest in the unit. It's more like a condo than it is a lease arrangement. So in terms of advising the client or the family member, I think it's got to be a collaborative arrangement, because there's different interests involved. There's the interest in making sure that the family member receives the best care possible, but also, financially, the financial arrangements are articulated and spelled out so that the family knows what their responsibilities are, and hopefully will be protected if it's a situation where they're going to be entitled to a refund at some point down the road.
Michael, I'm thinking, I get ads all the time, and some of these communities I know, they're senior communities, and they'll be renting or selling an apartment. I don't know if there's equity or not, but you're talking about some of them will be asking sums as high as $400,000 or $500,000. It seems like a lot of money to commit to something like this. And I guess it's a situation where you're covered. Maybe you have some ownership interest, and perhaps as funds dry up, they draw down on this amount, or this money is used for living going forward. I don't know. Have you heard of these arrangements?
Yeah, I have. And one of my other family members worked in a facility like that where there was, and I think that may be one of the reasons why the facility requires a large payment like that up front, is because if the financial resources do dry up, then they at least have a source of funding to continue the relationship, while the patient or the resident still resides in the facility.
I think one thing we have to keep in mind is the fact that these facilities run the gamut from senior housing to residential treatment to part-time disability to full-time disability to memory care, and they're here to help, but they're also there for profit making as well. Are there any thoughts you would like to share with our viewers or recommendations before we sign off, Michael?
Well, once again, to reiterate, you're right. There are a number of different options, and because of the cost involved, and because of the fact that there are different levels of care, from personal experience, the facility that my family member is in, they offer independent living, assisted living, memory care. So pretty much the spectrum of the care needs that the individual resident would need. And at each level, the cost changes. And the more care and more assistance that the resident needs, the more cost is involved, because you need more people to pay attention to that particular resident. In the big picture, though, it's obviously an emotional situation. You're dealing with a loved one. Usually, it's a parent or a family member that is in need of some care, and the person who's making the decisions for that individual is oftentimes a child or a close relative, and there's a lot of different issues that have to be factored into the equation. So it's just a matter of being very vigilant in reviewing the paperwork, understanding the nature of the transaction, and then trying to pick the best situation for that particular individual relative.
I think sometimes it might be helpful, Michael, for not only family members to be involved, perhaps an attorney who knows elder law and elder care issues, to look into these before someone signs on the bottom line. And I think what we should remember is that you really achieved great result where you were able to have the client get all of her escrow funds returned. So congratulations to you. I want to thank you so much for being our guest on Gracefully Graying, Michael. And I want to thank our viewers for watching Gracefully Graying. I also want to thank our sponsors on behalf of Gracefully Graying for supporting Gracefully Graying. Thank you.
Thank you, Henry.